Here the issue was Director of Public Prosecutions against Chris Durham, Ian Sandy, and Ian Bliss.
Now, Mr. Benjamin.
Good morning, my lord.
Good morning. We're familiar with the factual background,
Yes,
and the judgments below, so we don't need to be taken through that material.
yes.
It would be helpful to us if you could confirm what exactly you would like the court to do at the end of the day.
Yes.
And apart from that, you can go straight to the issues.
Obliged, my lords. My lords, as you are aware, I appear together with Mr. Keston McQuilkin and Mr. Pierre Brother for the appellant. My learned friends, Mr. Richard Clayton, Mr. Gerald Ramjean, who is to my far right, and Mr. Wayne Sturge, appear for the respondents. My lord, one tiny matter of housekeeping before I answer my lord's question directly, which is the papers have been characterized by a typographical error. The second named respondent, I think it's referred to as Salandi in the papers. It should be Sandy. It's a typographical, it's minor. And of course, we apologize for not picking it up.
So it's S-A-N-D-Y.
S-A-N-D-Y
So
would be
take
the
out
correct.
the A-L.
Yes.
Thank you. That's going to be the most difficult issue. Once it comes,
Well, my lord, my lord, in answer to my lord's question, in the papers I described this appeal as a challenging and difficult one, and the director brings it really for two purposes, or for two reasons. The first is that whichever way my lords and my lady decide the appeal, we hope to receive some guidance as to the interplay between the criminal law proper, in particular the Evidence Act, and the amending provisions on the one hand, as well as public law intervention in the other, if I could put it like that. And my lords have got the flavor of that from my written case. But secondly, and far more importantly, there are probably, and this is just an approximate number, 400 plus pending murder charges that constitute the workload in relation to that charge. It's not the only workload of the director. And so circumstances like this, either identical to or similar or a variation of, are likely to occur on a repeated basis. And therefore, far more narrowly, if my lords and my lady felt able to, I fully accept that this is not an appeal from a criminal decision. In other words, it's not an appeal in respect of conviction and so on. But if my lords and my lady felt able to, such guidance that you'd be able to provide on that narrow issue, and perhaps more important issue, would be gratefully received. As far as the specifics of this matter is concerned, obviously the director intends to study the judgment, and he will then make any future decision that he thinks appropriate, again in light of whatever guidance you give on the first two issues that I've identified. So that's how he will, and he intends to proceed in relation to the two remaining respondents. As my lords and my lady are aware, Mr. Durham has sadly passed. It doesn't impact him. So, my lord, that's my order of priority, if I might put it like that. So future guidance, but of course there is a live case with live active considerations for the director to consider in relation to those two respondents. My lord, I hope that that provides an adequate answer to my lord's question. Subject to any other query along those lines from the board?
When you say there's a live case, if I could refer you to paragraph 41 of your written case.
Yes, my lord.
Yes, where you submit that at this stage, given the considerable time elapsed and the quashed indictment, the question is not whether the matter needs to be sent back to the criminal trial court for consideration, but what is the principal answer to guide future courts.
Yes.
What is that telling us?
So, my lord, I didn't hear the last words of that question. What does that...
What is that telling us in relation to what you describe as the live case? Is it the intention of the director, if the appeal was upheld, to renew the indictment?
He would only consider doing that in light of what my lords observe. In other words, my lord, he hasn't made a decision that he's going to, he hasn't made a decision that he's not going to, but he will certainly properly, I think, have regard to whatever falls from the board's lips, in writing, of course.
That's what I wish to know.
Yes.
Thank you very much.
But, my lord, I don't want to overdo it, but I do want to emphasize that the order in which I put things is really reflects his concern, if that assists you in any way.
Thank you.
So, my lord, I fully appreciate that you have a command of the basic facts. I suppose, just in fairness, there are just one or two items of fact that I would just like to draw to my lord's attention. Of course, you have the chronology, and you have the statement of facts and issues that is an agree between the parties. Just to let my lords know that the victims of this crime were all young men. Mr. Kenty Murai was only 19. If you want a reference, electronic page bundle 2245. Mr. Kewanson Louis was 25. EB reference 2257. But Mr. Mubarak Calder was 15. 2251. And I simply draw that to my lord's attention, well, for two reasons. It might be something that you hadn't picked up, although that's unlikely. But if you hadn't picked it up, in the context of the director, which we've attempted to explain, the director not having put before the board an affidavit explaining his course of action, we felt it was important to draw to the board's attention the use of at least one of the victims being a minor. And therefore...
Sorry, being...
A minor.
Right.
And therefore, it's, if I may say so with respect, a self-evident public interest reason, not just because this is a serious crime, perhaps the most serious crime, committed with firearms, but involving a minor. So those are just, it's really just a matter of public interest, an element of the public interest that we would ask that the board have very much in its consideration. Now, my lords, just again, briefly on the facts, or secondly on the facts, there is a criticism directed at the director in relation to what I would describe as his conduct. And a careful perusal of both the judgment at first instance and that of the Court of Appeal seeks to focus that criticism by separating the conduct of the prosecutors, Shah and Jaglal, and distinguishing their position, described in very laudatory terms as being courageous, I think, by the first instance judge, and appropriate and ethical, whereas the director himself has come in for some criticism. With respect, and we'll take you to the facts that we think that support it, we say that that attempted separation is misguided. The director clearly does not prosecute in every case, although it is to him or her alone that the Section 90 responsibility properly falls. I trust I'll be forgiven for shorthand, Section 90 of the Constitution, of course. And therefore to commend the prosecutors for their disclosure orally, first of all, to their colleagues by telephone, as well as to the criminal judge, Mr. Justice Devan Rampasad, which they did by the 17th of May, 2019, followed by the written disclosure of the important document, the notes of briefing, which I'm going to take you to almost immediately, within a few days thereafter, the 22nd of May. But at the same time, to castigate the director's decision based on his appreciation, with which you may or may not agree, of the role of the safeguards within the criminal trial in general, but more particularly the provisions of the Evidence Act, we say is unfair, inappropriate, but also not particularly helpful. We say, with respect, that the prosecutors acted at all times in accordance with his advice and direction. That is to say, when they made disclosure on the 17th, orally, and followed that up on the 22nd of May 2019 by the written disclosure of the notes of briefing, they were acting as he had directed and in accordance with two things, or three. A, the tenets of the profession, as codified in the Legal Profession Act. B, his code of conduct, because he's adopted it. And three, in accordance with the general policy and direction of the director himself.
So when these matters were drawn to the attention of the defence team,
yes,
and the disclosure made, that was with the express authorisation of the director?
Absolutely, my lord.
Yes.
It would be inconceivable in matters as serious as this that the director would not literally, A, be consulted, because these are, I mean, you may not have picked up the designation, they're State Counsel 3. So within the hierarchy of the Department of the Director of Public Prosecutions, of course, there is the DPP himself, the director, there's the deputy, there are assistant directors, and there are several State Councils, 3s, 2s, and 1s. So they are relatively senior because, of course, they're giving the responsibility, but they are not ultimately the final decision makers, because in accordance with Section 90, which I will take you to in a moment, you will see that the director, A, acts of his own accord, but B, can designate or delegate decisions pursuant to Section 90 to them.
So in response to Lord Lloyd Jones's question, are we to take it that the prosecutors in this case came to the director or communicated with the director and obtained his authorization to do that which they did?
Yes.
Thank you.
The way that I would put it, because of course I want to be careful about giving instructions, I began by, I own up to the fact there is no affidavit. But I want to be very careful by saying to you that at all times, State Counsel acted in accordance with either the director or whoever was acting at the time. Because you would have picked up, I think, in the record that from time to time, Ms. Joan Honoré Paul was the acting director of Public Prosecutions in his absence.
So some of the matters may have been taken to the acting.
Absolutely.
Yeah.
Absolutely.
Thank you.
I'm obliged. There was one small point I was going to add, but it just slipped out of my mind. It will come back to me momentarily.
Well, the absence of an affidavit clearly exercised Justice Quinlan Williams, didn't it? Because she gave directions and was clearly disappointed that there was no affidavit served in compliance with that direction. You say there was no need for an affidavit, is your position, as I understand?
Yes, that's how I put it in my written case, and I've attempted in the paragraphs that follow that relevant paragraph to explain why. But in any event, I would also add, but I don't want to make too much of it because this is not how I want to spend my time, her directions were given on a fairly, I think it can be objectively described, a very aggressive timetable, because leave was granted, applied for on the 23rd, granted on the very same afternoon. The fixed date claim form was filed the next day, which would have been Friday the 24th. Submissions were heard from the respondents the following Monday, the 27th. State counsel who turned up said that they were not ready, and I'll just explain that in a second, and they were allowed to make their submissions and an affidavit, an answer to my Lady Carr, on the 31st, and the speaking note that they filed, of course, is in the record. And what I want to say about the speaking note is that although it's fairly succinct, it more or less captures the gist of what is set out in our written case as to A, the appropriateness of judicial review by way of intervention in a matter which is pending, and B, the specifics of being able to rely upon the Evidence Act provisions. The one matter that I haven't mentioned by way of chronology, and I appreciate my Lord Reed said you have a complete command of that, which is to say the submissions were heard from the state on the 31st, and the judgment was given within a few days on the 3rd of June, which is important to bear in mind that that was the date upon which the trial should have resumed. And the one other matter, before I leave the factual evidence that I just want to emphasize, because we've spoken in general terms, is that the board is aware, I'm certain, from the papers, that the prosecutors, because they had had the interview with Mr. O'Neill Benjamin, same name, no relation, they regarded themselves as potential witnesses, and the director regarded them as potential witnesses. And it was for that reason, coupled with the unavailability of any other prosecutor for the month of May, that they made the applications to the criminal judge to adjourn the matter to the following assize months, which began on the 3rd of June. Can I, with those preliminary remarks about the factual sequence, at least the chronological sequence, invite my lords and my ladies' attention to the actual notes of briefing. You will find them on the electronic bundle, page 339 and following. I know that you've looked at them. They are reproduced in part in the judgments down below, certainly.
Yes.
Justice
Well,
Williams.
speaking for myself, I know some of my colleagues have looked at them. Speaking for myself, I haven't.
You have not?
I've simply read the judgments below.
Yes. So, well, I trust that my lords' colleagues will forgive me for taking it at slightly more length than I otherwise would have done. In any event, my lords and my lady, it's a short document. Can I suggest that I approach it this way? Can I simply ask the board to just reread it or read it for the first time, at least pages 339 to 341, and then I'll make my observations and submissions on it.
Yes, if you give us a few minutes, we'll do that.
Yes.
Could I just pick up on Mr. Jaglal's questions, one of them on page 341? Just a point of information. He referred to several statements to the police, interviews which were videotaped, and evidence in the magistrates' court. So Mr. Benjamin gave several sworn statements, I presume, to the police, videotaped interviews, evidence in the magistrates' court over a number of days in June, July, and September 2009. Is that right?
June, July, September, October. Yeah, dates don't matter, but yes, all the way down to November 20.
And cross-examined on behalf of each of the respondents.
Yes, so yes, Belinda, you are right. The extent of the duration of the hearings is a little bit longer than what you've indicated, but yes, that's right.
Thank you.
Yes, thank you, Mr. Benjamin.
I'm deeply obliged. So can I just make a few brief observations? I'm not going to reread it, but certainly if I can invite your attention, my Lord, back to 339 to start, and simply to say that in answer to the request, and I'm sort of approximately line 5, in answer to the request of Mr. Benjamin to recall his account of what transpired on the day and to give details and so on, it's described by Mr. Jaglal and Ms. Shah as he proceeded to give an account, I'm quoting now, to give his account consistent with his statements to the police, exactly as Milady pointed out, and with his evidence as given in the magistrate's court during the preliminary inquiry in which he'd been called upon to give evidence and to be cross-examined on several occasions. And then he goes on to proffer some information about the role that he played, and so that's the first indication of sort of him seeing himself in a particular role. Again, you've read it, so I'm not going to read it out to you, but you get the gist of what he's doing there. He then, in the next paragraph, gives some background as to gangs and the accounts of gangs operating in the area. Lady Rose gave a speech recently in which the title was Sordid Facts. So these are sordid occurrences. It is part of the landscape in which the country has to operate. And there is a description as to the various loyalties, if I can describe them as that, among the various gang members. Some are Muslim, some are Rastafarian, others Rasta City, and so on. So, just pausing there, up to this point in the account, remembering that it went on for some 90 minutes, Mr. O'Neill Benjamin has said nothing to the effect that would contradict either his original statements to the police, his testimony in chief, and or his cross-examination before the magistrate on the preliminary inquiry. At the very bottom, he gives the first of explanations. In answer to the question as to whether he's been contacted, my lords, I'm at the very bottom, he indicated he's well informed as to what is taking place in the prison. And the accused persons have sent thanks to him and appreciate him giving evidence, albeit against them, as they enjoy a level of security in prison as opposed to being exposed to the outside. So just pausing there. So that's his account. No way of verifying it, I suppose. But he says, well, they've thanked me for doing what I did. He then goes on to say in the very same paragraph something slightly curious but important, which is to say that they offered him a sum of money for him not to give evidence. And he identifies the sum, but he says he wasn't interested because he doesn't need the money. So again, pausing there, if that were true, it would certainly be consistent with somebody who willing or wanting him not to give evidence against them. I think that's just self-evident. The next paragraph is interesting because there he is expressing a view more than that of a witness. He says he is aware that his evidence makes or breaks the case. And he expresses a view that the jury would not come back with a guilty verdict. Separately, he says he is not fearful of them and so on, because in any event, they've been sort of isolated, so they can't get back into gang activity. Then there's another instance of, again, using the sordid facts that I referred to. That's my compendious title. He was charged with the deceased Zafar Calder, who is related to Mubarak, for the offense of arson in January 2009. That matter was dismissed. Sorry, let me not leave out the second line because it's important. I apologize. Charged with the burning down of the house of Rodney Caliste, the relative of the accused number 3, Dion Caliste. So he's in the thick of it, if I could put it like that. In any event, he says the matter was dismissed, and he exculpates Zafar, but incriminates himself. And he gives, again, an explanation for doing what he did. He then, in the next paragraph, makes comments about my learned colleagues. I won't detain you with that. And then, if I go down to the next paragraph, which deals with Mr. Durham, who's no longer with us, expresses a view about the accused and what he knew or didn't know, whatever, I don't think that's worth very much. And then at the very bottom, we come to what brings us here. He proceeded to say that all of this was all part of his plan for the good of the community. He continued by saying, and this is in bold, and that bold is not us, that's put there by Ms. Shah and Ms. Jaglal, there were no men in the truck, he says. He did not see these 3 accused persons, but he named them, and he did what he had to do to bring a level of peace to the community of Diego Martin. So just pausing there, that's a second sort of explanation or qualification, because earlier he said something slightly, well, not slightly, markedly inconsistent. He says 2 things, that the accused thanked him and that the accused sought to bribe him. But here he says, well, I didn't see them, and I did what I did because I'm a sort of vigilante type character. He expressed himself satisfied with the calm that's been introduced into the community. And then Mr. Jaglal taxes him on it over the page. Well, why are you doing, what do you expect us to do with this? And why is it that you are saying this now? So that's important, because it's timing. Because as my lady pointed out a moment ago, the preliminary inquiry took place some 10 years before, and he's saying this fairly late in the day. He responds, well, I achieved my objective. And in answer to, well, what happens next? Well, you go ahead and do your work, ask questions, do your job, get convictions. And that this is important for the point that I've already made, but I don't want to spend too much time on it. Here are the prosecutors making it absolutely clear to him, whatever his role is, theirs is very different. They are ministers of justice. And I say with respect, as are all members of the department, including the director himself. I am coming to give evidence, and I will answer as I did before. I am just saying this to you as we are talking, and it's just between us. So that has the tone of a confidence, purportedly or allegedly. I'm not, this is just between the 2 of us. And then they say to him, well, we wanted to get in contact with you in relation to the crime scene. But just at the very bottom, just to support evidentially what I said at the very beginning about that Mr. Jaglal and Ms. Shah make it clear that they will need to confer with the director. Now, just over the page, you have 342. I don't propose to ask you to read it, but just to kind of finish the sequence, because just in terms of time, you will recall that this happened on the 23rd of April 2019, and over the page you will see a statement, I'm going to summarize it, a statement from Police Constable Huggins, who was tasked by the Director's Department to go and seek to get a statement in writing from Mr. O'Neill Benjamin to see whether he would repeat and affirm and endorse what he had told the prosecutors. And you will see that at the bottom, and this was done right away, and the very last paragraph you will see that PC Coggins went to his home on the 8th of May 2019 with another police officer, and they asked him for a statement, and he declined to provide the same. So just pausing there so that the statement on its face three things about it. Firstly, on its face, it is itself inconsistent or contradictory, or at least there are elements in it which go in two different directions. The second point about it is that insofar as Mr. O'Neill Benjamin seeks to provide an explanation as to why he was doing what he did, on the one hand he says, well, they thanked me. On the other, they tried to bribe me, which would be consistent with the truth of what he said before the magistrate's court. And then thirdly, he says, well, I did what I did in order to introduce peace into the community. And that, of course, trends in the opposite direction. Thirdly and finally, even though he is specifically requested by the police on 2, if not 3 separate occasions, to provide a written statement, he declines to do so. He's not prepared to put his name to any of the things, apparently, that he said. And so, my lords and my lady, I know where I'm going. There is a serious question as to the reliability, cogency, consistency of what is said here.
By that you don't, I think, mean the accuracy or quality of what prosecuting counsel heard.
Absolutely not.
The consistency of what Mr. O'Neill Benjamin said.
Substance, indeed, my lord. Yes, absolutely right.
There's no challenge to the accuracy of the...
There is no challenge, and there has not been any challenge to the accuracy of the recording or memorializing, as the Chief Justice put it in his judgment, by the prosecutors as to what was said by them. What was said to them. They quite properly, and as best they could, carefully recorded. I fully accept it's not a transcript. I fully accept that. But yes, my Lord Briggs, the Director regards it as a reliable account of what was said to them. But a reliable recording of that account is very different from the reliability of the content of what it contains. And I put it like that because, as my lords will know from my written case, I have in more than one place contrasted these untested, unverified, not endorsed statements with the evidence of Mr. O'Neill Benjamin given over several months, being cross-examined by some of the leading lights of the criminal bar in Trinidad and Tobago. So, my lords, there are two sort of strands, although they converge to the legal part of my submissions. The first is that which I opened with, which is whether or not it was appropriate for there to be a judicial review application in respect of the Director's decision to continue with the prosecution. Framed as a refusal to discontinue, but that's, I think, as a matter of substance. I think my lords will know from my written case that I think I invite the board to treat it as a matter of substance. And the consistent trend of the case law, again, in summary fashion, my lord, is that matters such as this ought properly to be dealt with in the criminal proceedings, especially if, as the Court of Appeal, but not Justice Quindon Williams, came to the view that the continued prosecution was an abusive process. An abusive process within the meaning of Bennett, Warren, and a whole host of cases with which I know the board is very familiar, and particularly Lady Carr is very familiar with the Hamilton line of cases. So just a couple of small points about the abusive process decision before I come back to give my broad, high-level submissions. Firstly, it did not form part, we say, of the application for judicial review before Justice Quindon Williams. It was not one of the grounds. And in order to make good that submission, can I just invite my Lord's attention very briefly to the proceedings. You will find them, the application for judicial review at page 8 of the electronic bundle. Sorry, that's the application for leave, and I'll bring your attention to the fixed date claim form in a minute.
So the application was what? Unreasonable, illegal, procedurally improper and unfair?
Yes, really. So it's a small point. I don't want to take too much time on it, but I'm just making the point very, very quickly and very modestly. As my lady correctly points out, if you go to page 12 of the document, the grounds as you correctly summarize. And apart from unfairness, there was an allegation of abuse of power. That's on page 13. And then the grounds, the basis for the grounds in terms of the legal material upon which those grounds are set out is also set out, and certain cases are relied upon. Randall and the Queen, Doody, Reese and Crane, section 14, and so on. So that's one small point. So that the application, we say, was not premised or based on abusive process. Second small point, again purely procedural. If I invite your respectful attention to page 16 of the record, where the respondents say to the court whether there is an alternative remedy, they say, and I quote, the intended claimants have no other alternative remedy other than applying to the High Court for judicial review.
That's page
16, electronic bundle, under the heading alternative remedy, my Lord Joines.
Yes.
And so I say in answer to that, this is my submission, factually that's not correct. Because on the very same day, they told Justice Rampasad that they had two alternative courses. One was to make an application to him for an abusive process, and the other was to file an application for leave for judicial review to challenge the director's refusal to discontinue, they having written to the director the day before on the 22nd of May.
Is there a record of that submission?
Is there a record of
that submission? I know you place reliance.
Oh, sorry.
Where
yes. Oh, sorry.
There is.
I thought you meant my submission. Yes.
No.
I'm going to take you to it now. Electronic bundle, page 1319.
1319.
1319. Can I read from line 22? I hope you have lines.
Yes, we do.
Yes. Mr. Ramby made it very clear that our desire to file an application for a stay on the basis of abusive process, and we have let me just correct myself. This is Mr. Sturge reporting, I think, to the court what Mr. Ramby had said. Mr. Ramby made it very clear that our desire to file an application for a stay on the basis of abusive process, and we have the learning with us, which we can put in writing and exhibit the relevant cases. Mr. Ramby has indicated that there is a very different application to the judicial review, which we also intend to take if need be, with the proper course, etc., etc. So I hope that helps my lady. So that I was simply on the very small, these are small procedural points.
I'm sorry, Mr. Benjamin, to interrupt. You said that they said to
Yeah, so the first would be...
Justice Rampersad that there were two alternative courses.
Well, sorry, no. Two courses, one alternative to the other, is what I meant to
One was
convey.
judicial review, the other was abuse of process within the criminal proceedings.
Absolutely, my lord, yes. If I didn't state that clearly, that's entirely my fault. I apologize for that, my lord.
Not at all.
So my simple point is that they told the criminal judge that on the 23rd, on the morning, that's the transcript that you just looked at on page 1319, and then made a choice that afternoon. And it's a choice that has two parts to it. So they made a choice not to file the abusive process application before the judge, the criminal judge, before whom they had appeared, and before whom it was discussed in broad terms, and they decided instead to file the application for judicial review challenging the director's decision. At one stage, apparently, they were almost inviting the judge himself to hear the judicial review application. Now, my lords, just by way of parenthesis, I know that most of my lords are very familiar with the structure of the Trinidad and Tobago judiciary. Through three sentences, criminal matters such as this kind of serious offense are all heard by high court judges. No concord judges or anything of no creature such as that exists. It's a very simple judicial structure. Magistrates who deal with simple matters and do preliminary inquiries, and high court judges. So that's one. Secondly, within the High Court of Justice, a broad division again, civil judges, criminal judges, and family judges. I guess your equivalent of, my lord's divisions. So that in this case, and I should add, I'm sorry, forgive me for stating the obvious, a High Court judge of Trinidad and Tobago is not an inferior body for the purposes of the Judicial Review Act. Self-evident observation. So that in this case, while a matter was being actively dealt with by a criminal judge, it wasn't being case managed. In other words, it wasn't being dealt with by a criminal master, because we also have, as my lords are familiar with, criminal procedure rules. The analog of the civil procedure rules, cases are managed up to a particular point by a criminal master, and then they land on the docket of a high court judge, who will normally sit on assize for a month or 2 or 3. So that's the circumstance in which you understand the chronology given as to why Justice Rampersad was sitting. So that in essence, or in practical terms, one of the consequences of Justice Quinlan Williams' decision and its affirmation by the Court of Appeal was, as it were, to reach into, pardon my analogy, reach into the pocket of Justice Rampersad, into his work docket, his pocket, and affect one of his cases, and then hand it back to him, saying, well, we've decided this. The indictment is quashed. And as a consequence, on the 3rd of June, what happened was representations were made to him that the indictment having been quashed by a co-equal judge, he had no choice but to release the accused.
There were courts of concurrent jurisdiction.
Absolutely, beloved. Yes, courts of concurrent jurisdiction.
And the trial had commenced the previous week, I think.
Yes, I mean, I want to be careful how I kind of explain that, because, of course, it was adjourned on the basis that the prosecutors were likely to be witnesses, and therefore it would be improper. And as a matter of fact, I won't take you to the detail of it, but what Ms. Shah explains to Justice Rampersad on the 23rd is, since my friends have signaled very strongly that based on our disclosure, they intend to make an abusive process application to you, and we are going to be witnesses, it would be wholly improper for us to even attempt to respond to that.
Yes. According to the précis that we have, the prosecuting team was replaced on the 23rd of May.
Yes, my lord, the only thing I want to be careful about is I can't say who who, I can't identify the prosecutors, but certainly that conversation was had with the director and the
Yes.
yeah.
And
can I just give you a page reference to answer one of my Lord's questions? That the jury was selected, you will see that on page 1334, electronic bundle, page 1334.
so the jury had been selected, and evidence had begun to be led?
No, my Lord. No.
Had the defendants been placed in the charge of the jury?
My Lord, of that I cannot be certain. We can check, but I don't know the answer. I don't know the answer. And in other words, I don't know the answer. I'm a little bit concerned as to whether the answer is to be found in the record. I'm not certain that it is.
The jury had been selected. Had they been sworn?
They had.
Yes.
Thank you.
Obliged. I'm grateful to my little friend.
And that had happened
On which date, yeah.
from the précis. The trial began on the 17th, so presumably the jury was selected and sworn that day.
Yes.
I'm not sure how important this is, but it's helpful to have an
Yes,
idea of
my Lord, yes. I mean, I know that you didn't want us to redo the facts, but I know that my Lord is also anxious to be accurate. So it's only in that context. So, my Lord, my overarching submission, conscious of the time, is that the respondents, contrary to their statement in their application for judicial review and the fixed date claim form, did have an alternative remedy. Clearly, that alternative remedy was abusive process. Clearly, that abusive process was canvassed with the criminal judge. It was wholly wrong, we say with respect, for that not to be drawn directly to Justice Quinlan Williams' attention. That's really what we say about it. And I'm not making a procedural point. I'm not on, my learned friend responds to what I say by saying, well, hold on, Benjamin, meaning me, you can't get into procedural fisticuffs because you didn't make an application to set aside and you didn't do any of that. With respect, I'm not on that. I am on a matter of substance and principle, and the substance and principle is, as recorded by this board's decision, in Sharman and Twine, and cases which both precede it and come after it, criminal matters are for criminal judges and juries, importantly, and the courts are astute to avoid the unnecessary duplication and wastage of their precious resources, otherwise known as judicial time, by duplicating that process or a part of that process in a judicial review application.
I think complaint is made that this point wasn't taken below, not just by way of a set-aside, but in the submissions before Madam Justice Quinlan Williams, was this point taken?
And the answer to that is yes.
The alternative remedy point was taken?
Absolutely, milady.
And it's not mentioned in her judgment?
It's not dealt with. Yes, it's not dealt with. So remember I began by saying, if one looks at the speaking note, which I'll get the page reference for you in a second, the speaking note encapsulated what I've tried to say to you in my written case, which is that, and you get that, yes. So you'll find the speaking note on page, begins on electronic bundle, page 63. It encapsulates this case. And there was a heading on page 68, if I could just ask you to go to that very quickly, whether the claimant has an alternative remedy.
Right. Okay.
And she makes the very same point. Sorry, my colleagues make the very same point I just made.
I see. Thank you.
But besides the fact that I'm not taking a procedural point because that doesn't get me where I need to go, and besides the fact that the judge didn't really deal with it, I am on the point of principle and to sort of identify with the board why is it that the consistent case law, starting with, and I chose a 1999 starting point, Kebeline, the House, Lord Staines's judgment, coming to the board through the person of Lord Bingham in Mohit, repeated in Sharman and Twine. There's a little digression down under where the Supreme Court of Fiji, in the case of Matalulu, becomes involved. And they essentially say the following things: that decisions to review, or let me start again, judicial review applications to challenge a decision to prosecute should be rare indeed, for the reason that it results, apart from everything else, in an unnecessary duplication and delay. But also for the reason endorsed at paragraph 14 of the judgment in Sharma and Antoine, and I'll give you the EB reference in a second, also for the reason that it engages the polycentric decision-making process of the director. And polycentric is not limited to whether or not it involves a policy question or public interest question. It also engages that layered decision-making process that the director has to engage in order to decide whether to continue with the prosecution. My Lord Reed, sorry. No, I thought you were going to ask me a question. I apologize. So we say respectfully, that in this case, that what ought to have happened, and in fact, what happened, very unusually. So there is a description of this case as being exceptional. It was exceptional in this sense, that this was a matter that was a live matter before a criminal judge who could, and there is no argument to the contrary, very properly have adjudicated upon any suggestion or submission that to continue with the prosecution was an abusive process. That opportunity was intentionally sidestepped. And instead, the application for judicial review was filed before Justice Quinlan Williams, in respect of which he didn't make any comment about any of this. So I promised to give you the reference to Sharma and Antoine. My lords and my lady are well aware that I've put in my footnote, and my learned friend and I have cited the very same cases. But I do want to confine myself. Can I invite your attention to 3235? And I will make a series of submissions in relation to paragraph 14 to support what I just said as a matter of law. And then I propose to move on to the narrower point, if I may put it like that.
Could I have a page number again, please?
3235.
And paragraph 14.
Paragraph 14.
Yeah.
Actually, I think something's gone wrong with the paragraph numbering in this report of Sharma, hasn't it? It doesn't matter.
But tell me, lady, what do you see?
No, it is 14, it's right, but it's governing principles.
You've got it. You've got it. That's subparagraph 1 in paragraph 14, lady. So you're absolutely right. Yes, sometimes it's a bit tricky. So leaving out my lady's absolutely spot on, as usual. Governing principles, a series of paragraphs, numbered 1, 2, and it goes over the page. My lord and my ladies, I think it would be helpful if I could let you alone to read the next 3 pages, the whole of paragraph 14, and then I'll make my submissions. No value in me reading it out to you.
Thank you.
We can stop at little Roman 5, presumably, on the top of 789.
Yes, you can.
Yes.
Yes, because I don't want to make the point at 6.
Yeah.
Again, I've made it already.
Yes, I
So
think
just two matters. Oh, sorry, Lord Jones. I just want to drive home 2 points as a matter of emphasis, as a natural segue into the next portion of my submissions. And the first is what I just said. So I'm inviting my lords and my ladies' attention specifically to page 788, letter F, on 3237, the great width of the director's discretion. That's in quotation marks from Justice Powell of the Supreme Court, adopted by the entirety of the board. As my lords will have seen, the great width of the director's discretion and the polycentric character of official decision-making in such matters, including policy and public interest considerations, which are not susceptible of judicial review because it's within neither the constitutional function nor the practical competence of the courts to assess their merits. And then just over the page, just picking it up, from the reference to Lord Lane at the very top of the page, 3238, in relation to applications in relation to abuse of process, we would like to add that statement of principle by stressing a point which is sometimes overlooked, it was overlooked in this case, namely that the trial process itself is best equipped to deal with the bulk of complaints which have in recent divisional court cases founded applications for a stay. So, my lord, that naturally takes me to the next part of my submissions, which is really the kernel of what we are concerned about, which is whether the trial process has adequate safeguards, or as it exists in Trinidad and Tobago, in order to vouch, as it were, the director's decision. Because, my lords and my lady, I want, if I may, make this point very respectfully. It might properly be the case that another director faced with the identical information as exists in the papers before the board would have made a different decision. That's an entirely appropriate and proper course. The question that the board has to answer, or will answer, and hopefully give the director and future directors guidance, is whether in this particular case and in cases like it, where there has been intervention by Parliament to amend the Evidence Act to deal with the evidential status of inconsistent statements, over and above that which existed before, and in addition to treating with hostile witnesses, together with the usual panoply of the ability, of a criminal trial judge to manage a trial process. So the judge, his primary function is to ensure fairness in the trial process, and absolutely, if we say with respect that the director's exercise of judgment, apart from polycentric and all of that, we say with respect that the director's exercise of judgment in this case was one that fell within, to use the shorthand, a reasonable band of responses, even though other directors, identically placed, would have come to a different decision. That's really our bottom line on the substance of it. So, my lords and my lady, can I invite you now to have a look with me at the Evidence Act as amended?
But ultimately, I mean, your position doesn't depend on whether the DPP's decision was an appropriate one or not. You would presumably say that even if it were inappropriate, the criminal process is perfectly capable of dealing with the point.
Absolutely, my lord. And I would go further. There is dicta from the board and other places that says, even if the director had made an error of law, see Kebeline, I believe it's Lord Stein, I'll get the reference for you in a minute, even if he had made a mistake, even if he misconstrued a provision, even if he misunderstood it, the way that Lord Bingham put it in that case was, well, there was a controversy over, in the context, of course, terrorist offences and how the relevant provisions worked, with burden of proof and so on. But even if that was the case, that would not ground an application for judicial review.
No, and the authorities, I think, say that the unreasonableness of a decision by the DPP isn't a ground for judicial review.
Absolutely, absolutely. And we rely on that, even though I haven't taken you to the detail of it. So I was just going to take you to the Evidence Act.
Could I just interrupt?
Yes, of course.
Following on that, because it's notable, isn't it, that the Court of Appeal relied on irrationality.
Yes.
You say the test under Sharma is exceptional circumstances in the context of judicial review. So is mere irrationality, if I can put it that way, enough on your case?
Absolutely not. Absolutely not. And I'm now proposed to invite you to the Evidence Act provisions. You see them in the bundle of authorities. And of course, I'm going to invite your attention to the specific provisions. Can I just make 3 preliminary observations? I have put before the board the following. I have given the board in a supplemental bundle of authorities, which you may or may not have had an opportunity to look at, and for which I apologize for the lateness of it. I have given you an extract from Hansard where the Attorney General, then John Jeremy, explains why he was inviting the Parliament of Trinidad and Tobago to pass amendments to the Evidence Act that effectively mirrored sections 100 to 124 of the Criminal Justice Act of England and Wales. I haven't put all of those.
I hesitate to intervene, but it would be more conventional to remind my lords of the Pepper and Hart criteria. And there are quite a number of points one can make, not least that this is a new one. But leaving aside the fact it's a new point, and leaving aside the fact that there's a certain amount of explanation that's got to be done to justify looking at the Hansard at all, one begins by looking at the statutory provision, considers whether it's obscure or ambiguous or simply incomprehensible. No dispute here about the promoter, but as my lords will know, I have much experience with this, there are very few Pepper and Hart applications which find favour. And
yes.
It would be helpful if my friend could approach it in a more orthodox manner.
Yes, it may be this isn't the most fruitful
My Lord, yes.
avenue for you.
Yeah, absolutely, my Lord. My Lord, I'm not making a Pepper and Hart type application. The board's jurisprudence is replete with examples of looking at Hansard if you want to identify the mischief.
Yes.
So that's all. That's really my point. That's why I put it before you. I don't propose to take up your time with oral submissions. If you wish to look at it, fine. If my lords decided it wasn't worth looking at, I'm fine with that as well. I do want to make the point, though, and of course it's vouched by what is said, and that I've already made, that in the context of the unsavory facts and the gangs and so on, all that was happening then was how do I put it? A strengthening of the capacity of the courts in an utterly fair and constitutionally appropriate manner to remedy the problem of failed prosecutions. That's really the point.
Yeah. Yes. Well, I think
that's a single sentence, my Lord.
all of us who
I've got it. Yes.
All of us who prosecuted or
yes, my Lord,
criminal trials will be very familiar with the situation where witnesses go back on their previous statements.
My Lord, forgive me for.
And it's obviously striking that the Trinidad legislation allows the previous statement to be admitted as evidence.
I'm obliged, my Lord. So, my Lord, can I invite you then to look at 2527, where you will see the provision, section 15H, and its analog, with which my Lords will be familiar, section 119 of the UK Act.
Oh, yes.
Page number, I'm sorry.
2527.
Thank you.
and I hope I don't get in trouble with my learned trend, but I wanted to say a little bit more before I said anything about section 15H. Well, just one piece of housekeeping. 2826C is the reference for a mistaken view of the law in Matalulu, decided by Justices Van Dusen, Keith, and French.
So not Kebilane, but Matalulu 2826.
Both. I haven't found the Kebilane reference, but it's in both. In fact, I'll go further. My recollection is that Matalulu was endorsed in Kebilane, but I will find you the reference. But certainly Matalulu for the time being. So the second disclosure by way of housekeeping is that I've also given you the extracts from what I hope, because of course I can't be certain, is the English and Wales bench book in relation to inconsistent statements. I've also given you the local equivalent. And I provided you with, now that you needed it, 2 English cases on section 119 in that supplemental bundle. One is Bennett, and the other one is, it also begins with B. Billingham. I've given you Bennett and Billingham, which are decisions of the English and Wales Court of Appeal on previous inconsistent statements. And again, my lords and my lady are far more familiar with the workings of these provisions than I am, but it's really done so as to provide you with some assistance. So 15H is part of a suite. It starts off at 15A, but it's part of a suite of amendments, all passed in 2009 by Parliament to treat with the issue of witnesses who are reluctant or recanting or suffering from amnesia or scared or fearful or who pass. Each of them are provided for, and so there is a provision that allows for hearsay in particular circumstances, but very importantly, this is really my fundamental point, very importantly, the use of each of the provisions is subject to safeguards. Safeguards that are either embodied in the statute or embodied in the case in the bench books as to how these provisions are to be treated with. In other words, what is the correct approach of a criminal judge? What would be the nature of the directions that he would give a jury if faced with such an application, including in the context of things that you're very familiar with, no case submissions, etc., etc. So I simply try to locate it within the panoply of tools. So now finally, with all that slightly long-winded introduction, 15H2527, when in criminal proceedings a person gives oral evidence and he admits making a previous inconsistent statement, or B, a previous inconsistent statement made by him, or it should be her, is proved by virtue of either sections 5, 6, or 7, the statement is admissible as evidence of any matter stated in it, of which all evidence by that person would be admissible. And then, just for completeness, when in criminal proceedings, evidence of an inconsistent statement made by a person is given under section 15D1C, which is one of those hearsay provisions that I just referred you to, the statement is admissible as evidence of any matter stated in it, of which all evidence by that person would be admissible. So I respectfully submit, I hope accurately, and as a matter of law, and you will correct me if I get it wrong, that this provision effected a sea change in the way that evidence was to be dealt with in terms of admissibility for its content, but also a sea change among the tools given to trial judges to manage the kinds of issues that the O'Neill Benjamins of this world give rise to. And my Lord Reed, I borrow your phrase to say that the workings of these kinds of provisions are known expertly like the back of their hands to two groups of people, well, three groups of people. Criminal judges, prosecuting counsel, and of course defense counsel. And what you see in the bench books and in the cases are different examples of how, and let's call it for what it is, how lies and or liars are dealt with. Just by way of, I don't mean to be, dramatic, are dealt with. Because they occur in the criminal justice system and they have to be dealt with. And so among the first things that you have to do consistent with what is set out in the bench books is identify or be satisfied that there's a potential for inconsistency. So that when you look at this case from the perspective of the director, it is not possible for the director to say what will happen. All that the director can have in his or her contemplation is what is likely to happen. And so what we say about that is, you look at the existing testimonial evidence and you look at the statement that we've looked at together, page 339 to page 341, and answer the following questions. However it arises, whether by way of an application to treat a witness as hostile or whether it is in response to cross-examination from the defense, is the statement inconsistent? And is it an answer to that inconsistency to say, well, no, it's not really inconsistent because Mr. O'Neill said he was going to repeat his evidence. And my Lord, let me just see if I can make that clear or good. Once Mr. O'Neill said, on the bottom of page 340 into page 341, I didn't see them in the track. That is inconsistent with the evidence that he gave in the magistrate's court, that he did see them. And without, again, trying to teach my grandmother to suck eggs, he didn't just say before the magistrate's court that he saw them. He was able to say how long he knew each of the accused. And in each case, it was over several years, and he explained why. This is in his evidence in chief. He was able to say where they lived. He was able to give a description of their clothing and all the rest of it. So that when one comes to analyze that difference, first question is it inconsistent?
But just pausing a moment. Section 15H wouldn't help the defence in relation to a contrast between what he said at the interview and what he had previously said in the magistrate's court, would it? Because the statement of the interview wouldn't be previous to the evidence that the defence is seeking to attack.
Absolutely.
It would have to be done on the basis that he had repeated what he'd said in the magistrate's court at the criminal trial, and at that point the defence would say, well, I can prove you made a previous inconsistent statement under sections 5, 6 or 7.
Yes, absolutely.
And then get it treated as missing.
Yes, yes, my Lord.
That's where we're going, isn't
yes.
it? Right.
But my Lord, again, the director respectfully says that the attempt on the part of the Court of Appeal, especially in Justice Rajkumar's judgment, to isolate by reference to outcomes. My Lord, remember those paragraphs at paragraphs 21 to 23, first of all, and then later on around paragraph 50. He says, well, these are the possible outcomes, and he describes them as perverse. So, my Lord, we say consistent with what my Lord just said, the opportunity for Mr. O'Neill Benjamin to be confronted, I'm speaking in general terms, by what he said in the magistrate's court, by what he said to the prosecuting attorneys, can arise on a number of different scenarios, is how I would like to put it. So, my Lord, I want to stay at a level of generality, precisely because while the number of options is limited, it's not possible to predict with certainty which one would occur.
Yeah. In practice, it's not unusual for the defence to put even consistent statements if they're trying to show that the witness has given a number of different versions on different occasions, and the line of cross-examination is, well, what version are you going to give us today? Yeah.
Absolutely, my Lord. And so what we say is that once the occasion arose, either for the previous inconsistent statement under 15H and or treating him as a hostile witness, First of all, the jury would be directed to identify what that inconsistency is.
Well,
and
how would he be treated by, as a hostile witness? How would that arise?
that would arise if he went into the box and either declined to say anything, a la Muldoon, or if he gave an account only consistent with his interview to the prosecutors.
So, yes, so he'd be hostile if he went in to the witness box and said, I did not see the men.
Yes, absolutely.
And that, in that scenario, but the minority judgment in the Court of Appeal said it's actually dangerous to speculate. There are all sorts of things that could happen. Mr. Benjamin could say another third version, fourth version.
Yes, my
In the
lady.
witness box. So there are unlimited possibilities, aren't there?
My lady, they are, and with respect, when I effectively made that submission, the gist of what I said to the Court of Appeal was, well, we don't know what he's going to say. We don't know what he's going to say because he's proven to be a little bit challenging. We know what he said, we know why he said it over an extended period of time, etc. But which particular version is going to emerge, of course, is a question mark for us, because we have to be honest about that in answering that question to the Court of Appeal. But what we tried to provide the Court of Appeal with was an identification of the relevant responses that the trial judge and or the respective legal representatives would have, irrespective of whichever scenario emerged.
Yeah. But in the first place, if the civil court could deal with abuse of process, the criminal court could certainly deal with any application to stay the proceedings, the criminal proceedings,
Absolutely
as an abuse of process.
Yes.
If that were not successful, the evidence can be led, we'll see what he says, and he's then cross-examined on his previous statements. And the judge can consider a no case to answer submission if one is made. And if that's rejected, the jury can consider the credibility of the evidence in the light of all they've heard. And if, notwithstanding that, they arrive at a conviction, there can then be an appeal to the appeal court if there was no reasonable basis on which a conviction could be reached.
Yes, my lord.
So there are a whole layer of procedural mechanisms to deal with the potential problem here.
Indeed, my lord. My lord, you've accurately summarized what I have in my written case, or what I've tried to advance, perhaps very clumsily, orally, to my lords. And so what we say with respect is that the courts below simply got it wrong when they tried, first of all, to say, well, there isn't that much of an inconsistency, because he's going to be saying, well, let me take it on, first of all, to the judgment of Justice of Appeal Rajkumar. Can I just give you the page reference, my reference to paragraphs 21 to 22 I mentioned a moment ago. That's page 268. And then can I invite my lord's respectful, and my lady's respectful attention to page 282.
Sorry, page?
I'm going to invite your attention to page 282, paragraph 55 and 56 of the majority judgment of Justice of Appeal Rajkumar, to make good the point that I made a moment ago in my exchange with Lord Briggs about inconsistency. And this is what Justice of Appeal Rajkumar says. A witness who gave evidence before the trial court that his earlier evidence before the magistrate's court was untrue could have his earlier statement put into evidence under the Evidence Act for the jury, as findings of fact to assess which version is true. In this case, the witness is indicating beforehand that his evidence before the criminal court will not be different or inconsistent, although it will be untrue. He then goes on to say, there will be no need for a jury to determine which of those versions is true, because both versions given to the courts would be consistent.
Well, you say that's true as far as it goes, but it misses out the middle bit, which is what he said at the interview.
Absolutely, my lord.
Yes.
And I say fundamentally, with great respect to this judge, that those sentences are not coherent, respectfully.
Well, they're not complete. There are other possibilities.
Absolutely, my lord. But I'm on the notion that one version says I saw them, another version says I didn't see them. And to say that they are not inconsistent, or to say that they are consistent in the way that it's expressed there, is, with respect, logically incoherent.
Well, I think what he's saying is that the evidence the magistrate's court may be repeated
Yes.
In the trial, and that is not inconsistent, but he's not allowing for the fact that the defence will have an interest in that event, leading the inconsistent evidence that was given to the prosecuting counsel.
Indeed, my lord. And my lord, can I...
So it's not incoherent, it's just incomplete.
Incomplete. My lord, can I gratefully withdraw the epithet incoherent and gratefully adopt my lord's summary?
It may be helpful for us to look at Section 6 of the Evidence Act.
Yes. So you will have that if you go back a few pages.
There's 2522.
Yes.
So Section 5 is for hostile witnesses, as I read it, and then Section 6 is for non-hostile witnesses. Is that right?
I think that is correct. Yes. Yes, Malik. And Section 7 for in relation to previous statements in writing.
Yes, so under Section 5, if the witness were to go back on what he had said at the magistrate's court, then Section 5 could be applied.
Yes, together with Section 15H, yes.
Yep, and if, on the other hand, he sticks to what he said at the magistrate's court, then he can be cross-examined on what he told the police officers at the briefing, and if he doesn't admit that he made the statements attributed to him, the police officers can then be led in evidence to prove that he did in fact make the statements that they recorded.
Prosecuting
counsel, yeah.
And that's why
Prosecuting counsel.
they wanted an adjournment, because they thought that's what would, if the matter went to trial, that's what was going to happen.
Absolutely. So again, not to drive home the point too firmly, but having discharged, pursuant to the director's direction, their ethical obligations, they understood that they were now in the position of potential witnesses.
Yeah.
And it just wouldn't do for them to go to trial and then run the risk if somebody says, well, I now call, if I put myself in, I now call Mr. Ian Benjamin to give evidence. Let him come from behind the bar table and go into the witness box.
And the point of Section 15H, subsection 1, is then to make the statements proved under Section 5 or Section 6, not merely matters that go to credibility, but actually evidence in the substantive evidence.
Absolutely, my lord. And that allows me to segue into, and therefore, what Parliament is contemplating by this section is that the jurors will be allowed, to the extent that you get to that point, the jurors will be allowed to choose a version or not, or reject it. That's the point. So that when you, as it were, again to use my analogy, put your hand into the pocket of Justice Rampasad and deprive him of the ability to conduct the trial that has already started in relation to a jury that's already impaneled. You say, and you do so on, again, Lord Hodge, adopting your description very gratefully, an incomplete analysis of the relevant sections, we say with respect, and you then come to the conclusion that the Director of Public Prosecutions, in light of those circumstances, legal circumstances, meaning the existence of the statute, the material before the magistrate's court, and I've tried to be very gentle with what Mr. O'Neill says in relation to why he does what he says and why he says what he does and the explanations that he gives. Some explanations go one way, some explanations go the other way, which with respect to the Court of Appeal, it's 3 pages, it's not subject to analysis. In other words, a highlighting of those obvious, how do I put it? The obvious tensions apparent on the face of the statement. That's my simple point. The Court of Appeal simply, pardon my French, cherry-picked that statement that appears at the bottom that simply says, well, I didn't see anybody. And I described that in my written case as out of the blue and belatedly. My learned friend hasn't taken issue with that in his response to what I said in my submissions. And so I asked the question, well, why should I make a decision to discontinue based on that? So that ultimately we say that an attack on the director's decision to continue these proceedings falls foul of both the injunction set out, leaving it to the criminal judge, Sharman, Antoine, and so on, but also are not consistent or are based on an incomplete analysis of the tools available to the criminal judge, which is the very policy that underpins those series of public law decisions that I have mentioned in my written case, as has my learned friend, and in respect of which there is no fundamental disagreement. And my lords and my ladies, just for completeness, I've just asked Mr. McQuilkin to help me find that paragraph. It's paragraph. So can I invite you to paragraphs 37 to 41 of Justice Quinlan Williams's analysis? I took you to. Oh, sorry, no. Did I get derailed? Did I not say anything about paragraph 56? Oh, I did. I got to the end, didn't I? Yes.
You mentioned paragraph 56.
I did, and I got almost to the end before my lord corrected me and I gratefully adopted incomplete. But if I can invite your attention to the very same point of analysis at paragraphs 37 onwards.
Mr. Bishop, at some stage are you going to address your submission at this stage is that it's for the jury, or there's who knows, cherry-picking the end of the notes of briefing. We know, don't we, that Madam Justice Quinlan Williams appears to have concluded which was the correct version of events, which was the truth.
Yes.
And you say it's not clear from the Court of Appeal decision, majority decision, precisely what position was taken. But if you look at the back of paragraph 58 that we've just been looking at in the majority decision at page 283, again, here is the Court of Appeal reaching a firm view on which version is correct. The prosecution is being maintained, seeking a conviction based on the evidence of a witness who has undoubtedly lied.
Yes. And so, my lady, my respectful submission, while I'm on it, my respectful submission on that is that, first of all, that's a conclusion not open to a judicial review judge. Not open to a judicial review judge answering the kind of question that this judge is answering here. So that's number one. And even if it were open, it's arrived at without any of the analysis that I attempted rather faintly to invite the board to conduct by a close reading of those 3 pages. So I say with respect that the findings, even on the assumption that they're open to either the Court of Appeal or Justice Quinlan Williams, definitive and firm and unequivocal as they are and repeated, I say with respect that they are unfounded and that they are in error and should be set aside by this board with respect.
Can I ask a question which you may not be in a position to answer, but I'll ask it just in case. Would the DPP, would the director consider that it was his duty when presenting the evidence of the Crown to the court to lead the evidence of the prosecuting counsel?
My lord, I don't know the answer.
About the inconsistency.
I don't know the answer. I can say that I am aware that the practice in Trinidad and Tobago has been to make disclosure and to make sure that all of the material is available to the defense to do with it what they want. I'm also aware from talking to my colleagues who are based here in London that at least some of them would feel duty-bound to lead the evidence. I say with respect that for the purposes of my case, whichever the preferred practice is or the adopted practice, it doesn't make a difference. What I mean by that is, if my lords accept any of the analyses that I've advanced in relation to the incomplete analysis of Section 15H and the inconsistent statements, I say, my lord, but if, let me leave it there. I'm not going to ask my lords to necessarily express an opinion on it. My lord, again, Mr. McQuilkin reminds me that if the document had been sworn, or perhaps signed, but certainly sworn, in other words, had Mr. O'Neill Benjamin, instead of fobbing off P.C. Huggins, given him a statement and then sworn to it, then certainly the director would have felt duty-bound to try to treat with the evidence.
But
in the way that my lord
would have been duty-bound.
He would have felt duty-bound if it was a sworn statement to treat with the evidence.
What's the difference between an unsworn oral statement to counsel, which is not challenged as being incorrectly recorded by counsel, and a signed or sworn statement? If it's an unqualified statement that what I'm going to tell the court at the trial is untrue, why does it matter whether it's sworn or not?
My lord, I don't think it makes a huge amount of difference. I'm just reporting to my lords what I understand the practice to be.
I don't really understand why there is a duty in one case and not the other.
That's what I mean.
Yes.
Can I just ask you about what you said a moment ago? You said that had Mr. O'Neill Benjamin given a sworn statement, the director would undoubtedly have considered that he should treat with the evidence. Do you mean that he should, that the prosecution should lead that evidence?
That is my understanding, my lord. That is my
that's your submission.
Yes, that's my understanding.
The difference, as I understand, would be that, putting it colloquially, he really meant it, if it's signed and sworn. But that's as far as...
Yeah, my lady, I'm not even sure that I would want to go that far, not because of its status, unsworn or sworn. The only reason why I'm hesitant is because of its content, for the reasons that I've already given. That it's literally all over the place, respectfully.
Yes, but we are to take it for the purposes of this appeal that the practice in Trinidad and Tobago is to make proper disclosure, as was done in this case, and leave it to the defence team to make of it what they will.
Absolutely, my lord. That way of putting it is consistent with what happened in this case.
Thank you.
Benjamin needed independent legal advice before signing a statement that incriminated himself and charged of perjury.
So I was going to invite my lords and my ladies' attention to paragraph 37 to 40. Can I just ask you to read that to yourselves? Well, include 41, please.
Sorry, you're taking us to...
This is for pages 91 to 92 of the electronic bundle. These are the paragraphs 37 to 41 of Justice Quinnan Williams' judgment. They're on the same point as paragraphs 56 and 57 of the Court of Appeal, on the topic that we are currently debating.
Yes, the point is she is assuming that the evidence given to the magistrate was perjured.
Yes.
And its repetition would involve perjury.
Absolutely.
And you say that she was not in a position.
No, she was not entitled to come to that conclusion.
And she seems to regard it as problematical in 42 onwards that the witness knew one of the accused and is himself not a person of impeccable
character,
antecedents.
Yes.
She's evaluating the evidence.
Yes. And my lord, one of the slight ironies of this case, although I don't intend to take you to it, is that the appeal in this case was heard by the Court of Appeal together with a sister appeal called Nurse. Both my late friend and I refer to it in our written cases. And in the Nurse case, the short version of it is that the learned judge there did, as it were, go through the evidence, come to a series of conclusions, make findings on it, and the Court of Appeal said, oh no, that's completely wrong. That's completely wrong. That should have been left for the criminal judge when they come to deal with it, including, if appropriate, an application for abusive process on any basis. And at that stage, so I just want to draw the connections together. At that stage, the case in Nurse was only at the stage of case management. It was being dealt with by a criminal master. It was not a matter like ours, like our Durham case, in respect of which the jury had been impaneled, and it was before sitting in the hands or the pocket or wherever you want to say of a criminal judge. Yeah. So that I simply draw that difference to the court's attention. That
is it in the bundle?
Yes, my lord. Of course, yes, it is.
Can you give us the page number?
Absolutely, my lord. I will give you that now.
Of course, we were talking about the judge, but I mean the default position is that questions as to the reliability and credibility of witnesses are for the jury.
Absolutely, absolutely, my lord. And I'm going to.
It would only be an exceptional case that the judge would give effect to his or her own view of those matters.
Well, two things, my lord. First of all, the page reference for this is 3548 of the electronic bundle of authority. And what we say is that in relation to, with respect, alleged exceptionality, in where you have a witness who has lied, or appears to have lied, or is said to have lied, with great respect, it's hardly a novel occurrence in a criminal matter, putting it as gently as I can. So that the basis upon which the court felt entitled to intervene, we say was contrary to principle, but also inconsistent with the actual facts of the case, meaning that the case was lied before another judge, contrary to their own decision in Nurse, and contrary to what we say is to be found in the bench books, whether ours or yours. And the gist of that, because I don't want to lose sight of trying to close off on this point, which is ultimately, as my Lord Reed just pointed out to me, that what ought to have happened, if you get past the halfway mark, is that it's left to the jury. And the way that a direction to the jury would go, because the Court of Appeal expressed itself in the following language: there is no conceivable direction that could possibly introduce fairness in this case, is more or less how it was put, both by Justice of Appeal Rajkumar and by the Chief Justice. That was not the position, of course, of the dissenting judge, Justice of Appeal Barrow. No conceivable direction. In other words, if you told a jury the following: identify the inconsistency, if you think there is one. Identify whether it's significant. Identify or consider whether there's an explanation, if any. And approach all of this material with great caution. But you have to decide which version you accept. That's a paraphrase, I accept a vulgar one, of what my lords and my lady will find in the cases of Bennett, Bellingham is the correct name, as well as our Bellingham, as well as some of our domestic cases. Consistently focus on the inconsistency, decide its significance, identify or consider any explanation. You decide for yourselves whose version or what part of the version you would accept, my lord.
It may be said against you that inconsistency of testimony is one thing,
yes,
giving rise to all the considerations which
yes,
you've eloquently described. But where a witness says in unguarded terms, unqualified terms, I intend
yes,
to give evidence which I'm telling you is completely false,
yes,
when I get into the witness box at trial.
Yes.
Is that just a question of inconsistency?
No, it's not. It's not. It is a question. It's a question of reliability and credibility. But the one thing it is also not. I'm sorry, my lord.
He's telling you that
yes,
he's going to go to trial and
yes,
give completely false evidence.
Yes. Yes, my lord. But the one thing that it is not it's not unqualified. That's my point. And that's why I took you to the terms of the actual statement. So he says, well, my lord, again, I don't want to over-egg my pudding. Whether what he says is a throwaway remark, whether what he says is something calculated, whether what he says is to be believed, it's to be taken in the context of all the other things that he says on the day, on that occasion, as well as what he said previously. But I am just confining myself to what he said in the course of that 90-minute interview. We say that the isolation of it, saying, well, I'm telling you this. Well, he said with respect, lots of things, some of which were fantastical, some of which were inconsistent, so that in order to assess it, and in order for the director to make a decision, it was, well, okay, I have to wait up, and again, pardon me for using gestures, I've got testimony on the one hand, and I've got this statement down here. And in terms of how the balance of justice works in relation to what his decision-making was concerned, I say the following things. I say he made a decision that he was fully entitled to make. That's one. Secondly, I say that, as I've said it before, that his decision was one that was well within the range of appropriate responses, polycentric as it is, trying to weigh up all of these things, including those inconsistent elements to be found in the statement. But, my lord, I don't run away, with respect, Lord, I don't run away from the fact that he did say, for what it's worth, I lied and I'm going to lie again. He said I'm a hero. He said I did it to introduce peace. They thanked me. Just, well, with respect, a lot of what he said is simply bizarre. But, my lord.
But are you suggesting that this would have to go to the jury as a previous inconsistent statement for them to weigh up, or are you suggesting that there would be substance in earlier challenges, such as an abusive process challenge or a no case to answer?
My lord, I'm suggesting that ultimately that this is a matter for the jury to weigh up. But could I exclude the possibility that the way that the evidence emerged, or had the respondents taken the course that they said they were going to adopt on the morning of the 23rd, that the case would have started with an abusive process application? No, my lord, I couldn't exclude that possibility.
The main point you've addressed us on really is a jurisdictional point. I mean, is this a matter for the civil courts, or is this a matter that should be left to the criminal proceedings? In whatever way.
Yes,
there are a variety of ways it might be dealt with. The difficulty for us is that if we accept that it's a matter for the criminal process, it's difficult for us to get drawn into the limits of the jury's competence and the judge's competence in relation to questions of credibility, yes, without going into the law on that, of which there's quite a lot.
Yes.
And that's not been the subject of the written arguments or the authorities that we have in the case.
My lord, you're absolutely right. And I want to add that among the things that was not, and I've said it already, but it's worth saying again, among the things that I did not have the opportunity to confront directly was the suggestion made against the director that his conduct, because the way that I read the cases on abusive process, certainly under Lim 2, Seelord, Dyson, and Warren, is that there normally has to be some sort of police or prosecutorial misconduct. Yeah. And I say that I didn't have an opportunity to, that wasn't put frontally as part of the case. And in any event, well, what is the, if I can ask rhetorically, but of course not impertinently, there was no misconduct.
What was said by the Court of Appeal was that it was a breach of Section 27.
Yeah, yes, and I'm going to.
That's the prosecutorial misconduct relied upon.
Absolutely. So again, premised upon the findings, which with respect we say weren't open to them at all.
But that is the Lim 2.
That's the limit of it.
So that's Lim 2 of the two.
Yes, absolutely. Yes, lady. Lim 2.
So, Mr. Benjamin, if the matter had gone to the criminal trial.
Yes.
Is there anything that was advanced in the judicial review which could not have been advanced on an application for abuse of process?
Not at all. Not a single iota. Nothing. At least that's my respectful position. Nothing at all.
Yes, thank you.
I'm obliged, my Lord. So, my Lord, in the remaining 7 minutes, and I don't propose to take them all up, can I just try to bring my submission to some sort of coherent close? But before I do that, I say in answer, in reliance in answer to my Lady Carr, that the allegations made against the director of a breach of the Code of Conduct of the Legal Profession Act, a misunderstanding of his own duty, non-compliance with the highest tenets of the profession. It's put in a number of, with respect, slightly stringent and I would say respectfully offensive ways, but not borne out by any of the evidence. So we say with respect that the learned director complied with his obligations, A, under the Legal Profession Act, B, under the Code of Conduct, of which he is the author, his Code of Conduct. And I'm not going to trouble the board by taking you to all of the relevant subparagraphs, but the board is probably very well familiar with the English equivalent. They are at a high level in substance almost identical, perhaps one inspired by the other, not uncommonly in the common law world and in the Commonwealth, so that he did comply with his own policy, respectfully, and he certainly is not guilty of any unparticularized allegation of misconduct of the sort that does figure in the judgments of the Court of Appeal. And we say with great respect that both as a matter of, to borrow my Lord Reed's phrase, jurisdiction, as well as a matter of detailed substance, as far as the respective tools available are concerned, that there was nothing at all that was advanced in the application for judicial review that could not properly have been taken by way of an application for an abusive process. And more than that, the respondents said as much to Justice Rampersad several hours before they filed their own application for judicial review. So, my lords and my lady, unless you have... Yes. Mr. McQuilkin reminds me that I was much too in a hurry to sit down, and I didn't make a submission on those paragraphs that I drew your attention to. I asked you to read them, and then I went on to something else. But my single sentence is with respect that the learned judges below, both at the level of the Court of Appeal as well as Justice Quinlan Williams, wrongly came to the firm conclusion that perjury had been committed, wrongly and incompletely analyzed the specific provisions of the Evidence Act and the more general tools available to a judge, and incorrectly came to the conclusion that it was appropriate to deal with these matters by way of a judicial review application, when entirely properly they should have been left to Justice Rampersad, and he ought not to have, with respect, his jurisdiction taken away from him or his role usurped. And it does not matter that the usurper was a judge or court of concurrent jurisdiction. That's not, with respect, judicial review. So, my lords and my lady, unless I can answer some of your more difficult questions.
Thank you very much, Mr. Benjamin.
Obliged.
Mr. Clayton.
My lords, my lady, I want to summarize the submissions I propose to make at the outset. The first is that it's settled law that judicial review is available in this context in a highly exceptional case. That's Sharma and many other cases. Second, the issue about whether there's an alternative remedy, I rely on Lord Bingham's principle enumerated in the Kay case, that the question is whether other means of redress are conveniently and effectively available to a party, they ought ordinarily to be used. And I've referred to that in our case. I then want to make the point, was neither convenient or effective for the respondent's case to be determined as for the criminal proceedings as the Court of Appeal found, subject to the way the case is being developed, which I'll come back to in a moment, orally, I hasten to say. The true position of this case is what, on the facts open to the Court of Appeal, was it open to them to decide this was a highly exceptional case. Now, I modified that submission slightly orally because a number of submissions have been advanced orally which simply are not reflected in the submissions that were made below. But leaving that to one side, and I'll deal with that.
I'm afraid that could be said in almost every appeal to this board.
Well, indeed, but I know Mr. Benjamin well, and I think we're all entitled to be judged by the same standards. Let me put it that way. That's the first point. They are actually different. The second is, and there are two quite significant concerns about the way this case is now put. First, the director chose not to put any evidence before the Judicial Review Court. None. And the submission made, and I'll give you the cross-reference, was that's contrary to Huddleston. My lords will remember it's a case frequently referred to by this, by the House, by the House, as it once was, by the Supreme Court, or indeed the Privy Council. The position is cards on table, face up. Now, an awful lot of effectively evidence was given by Mr. Benjamin about this and about that. But I do make this point at this stage. In the nurse case, the sister case, the director did put in proper evidence. And there is an element of a moving target about what we're dealing with. That's the first point. The second point, with respect, is that there's a complete lack of reality about the submissions which have been advanced for this reason. And I'm going to go to the detail of this shortly. On the 23rd of May, the prosecution team left, quite properly. And I want to make it absolutely clear, the prosecution team applied with the highest standards that the bar sets. And I make no criticism of them at all. But the reality is, there's been no prosecution team in place since the 23rd. None at the time of the judgment of the 3rd of June, none ever since. So all these submissions about the criminal case just take place in a factual vacuum.
But that can't. Sorry, it was adjourned in order for a new prosecution team to come in.
Yes. And
what happens next is the JR.
Yes.
That day.
Yes. I'll develop the point, but the fact is, there's never. Can I come back to that? My lady is quite right. That's when they step down. But the question one poses, I'm going to develop this pretty shortly, is there's been no attempt to expedite this. There's been no attempt to have a criminal trial. There's never been a prosecution case. Since the 23rd of May of 2019, no steps have been taken to action this case.
Yes. Well, I mean, that's obviously true. And that's presumably why, as I understand it, the DPP isn't envisaging recommencing the trial. But back on the 23rd of May, there was a jury that had already been selected.
But there wasn't a prosecutor.
But if you have who knows? But one would have imagined that given there was a judge and a jury, the Crown would have had to come up with a prosecutor if it hadn't been for the JR.
Well, I'll come back to that, but I'd want to at least make this point at this stage. In Trinidad, as my lords and lady will know, the prosecutors are all state employees. There's a chronic shortage of them. It's not as easy as all that to produce a person to prosecute.
Well, they got Miss Josephina Baptiste Mohammed.
Yes.
To appear before, no? She appeared in the civil proceedings.
Yeah.
And Mr. Benjamin in the Court of Appeal.
Yeah.
Yeah, but two had just been released. The two who had to come out of prosecuting this murder trial, and in my own experience as a prosecutor, if one trial collapsed, you got given the papers for the next trial pretty quickly.
Well, the point I'm making, and I'll maybe be simpler if I come back to it, is that there is an air of unreality about all of this because there is a vacuum at the core. There's nothing, there's no one charged with doing anything in this criminal case after the 23rd of May. And it means that actually the submissions, interesting as they are, take place in a factual vacuum. That's the submission.
There was a jury, it had been impanelled. Do we know whether the defendants have been placed in the charge of the jury?
Yes. Thank you. Can I just...
sorry, just one point of detail.
Sorry.
So when it does come back to Mr. Justice Rampersad, after the JR decision, did anybody appear on behalf of the prosecution at that hearing? When the judge is told the indictment's been quashed? Is it done on paper or what happens?
I wonder whether I could come back to that after the short adjournment because I see there's a debate.
Yes, certainly. Presumably the jury will have had to have been discharged at some point.
Yeah.
Well, that's also true. But can I just point to a number of the facts within this case which, in our submission, entitled "Subject to the Legal Debate," which I'll come back to after the short adjournment, the legal debate on previous consistent statements and so on. There are some discrete legal criticisms which I accept are separate. But I want to deal with the reality as it was before the actual Judicial Review Court, which was that there was no prosecution team in place, and these were the facts which were germane to their decision as to whether it was open to say it was an exceptional case. Now, the first thing, which is an important point, is that the defendants had been in custody for 10 years and 2 months until their release on the 3rd of June, the day of the Judicial Review case. Well, that speaks for itself. The speed with which the DPP responded to the pre-witness briefing is, with respect, unimpressive. On the 23rd of April, there was the pre-witness briefing. On the 29th of April, 2019, there was the last case management conference before trial. That's on the 29th. Nothing was said at that stage about the briefing. On the 16th of May, Police Constable Huggins gave a witness statement where he referred to, you were taking this as 342, where Mr. Benjamin declined, not this Mr. Benjamin, obviously, declined to make a statement. On the 17th of May, so that we're now nearly a month afterwards, the prosecution raised concerns before the trial judge. The prosecution telephoned junior counsel without giving particulars of a concern, and based on that, Ms. Sheikh, one junior counsel, made oral and written applications for the disclosure of the material. She contacted prosecution counsel and who was informed that they were aware of the request for disclosure and indicated that disclosure would be forthcoming. But the short point is, no disclosure was given voluntarily. It was only given as a result of a court order. On the 20th of the 20th...
Oral disclosure was given voluntarily, wasn't it?
Well...
In other words, junior counsel for the defence was told what had happened. What wasn't disclosed was the note of the meeting, as I understand.
Well, sorry, can I just... Yeah, that's correct.
So
but
there was oral disclosure.
Well, oral, the question may be, I don't want to get involved in a debate about fact and degree, but obviously concerns were expressed about it. On the 23rd of May, the prosecution of 2019, the notes were actually disclosed. But I want to go back to 2441, if I may. Just to remind my lady and my lords about what actually... So it's 2442. You can turn that up, please.
2442.
Yes, please. It's paragraph 20.
And what is it?
This is an affidavit of, forgive me, I go forward to the front. This is a disadvantage of being.
This is a summary.
It's of. Sorry.
I think
Must be the page.
I think it's the appellant's written case.
Oh, I'm so sorry. Is it the appellant's written case?
Yes, it is.
Oh, I'm sorry. I apologize. I was told it was a witness statement. That was incorrect.
Yeah.
But in any event, what we're told at paragraph 20 is with respect of some importance. This is what's told in the morning at 10:51. So obviously a lot of this has happened before. That prosecuting counsel were now potential witnesses, that the trial procedures included provision for inconsistent statements or hostile witnesses, that the criminal trial was to be proceeded with, that alternative prosecuting counsel needed to be assigned by the start of June. So there was a hiatus there, and there would be a response to the pre-action letter. On the 20th, so that was.
You said this was important, so what is the importance?
The importance is the fact that, with this, the point I'm drawing attention to is that the decision of the prosecuting team to stand down must have been before the conversation, because the conversation in court is at 9:51, so it's all happened before then. I can't obviously say when, but before then anyway. And judicial review proceedings were brought, judge grants permission, and then on the 27th of May, and in our submission this is important, the judge adjourned the case to allow the DPP to adduce evidence, and that's clear from the judgment 76, paragraph 2 of the first instance judgment. So the DPP had every opportunity to put evidence in. And with respect, it's very difficult in this court to be dealing with the sorts of suggestions made by Mr. Benjamin as to what might be the position, what could have been the position. Why on earth not just put it out there in the way that they did in the nurse case? If there is a practice, the court is entitled to know that. We are entitled to know that. Instead, we're faced with suggestions made in court, and I'm not making criticisms as to their veracity, but it isn't a very fair process.
There is the contemporaneous note of seeking instructions on the way forward from the DPP.
Well, it's with respect, my ladies, rather and more important than that. In judicial review, as I've said, cards on table, face up.
Right, okay.
And there's just a non-response and then to be dealt with. And I'm going to demonstrate in other instances, the submissions keep on shifting in this case. For example, just to choose an example, no submission of abusive process before the trial judge. No.
No, everything else is mentioned, but not abusive process.
No. Well, I'm not sure everything else, but that was simply the most striking example. I mean, I don't claim to
Well, a number of alternative ways of dealing with the issue were mentioned. I mean,
I agree, and we may need to look at that.
I know case to answer submission, leaving it to the jury to assess credibility, the role of the appeal court.
Yeah.
But as you say, abusive process wasn't mentioned.
No, that certainly wasn't mentioned. But I do want to make a point, call me old-fashioned, that putting evidence before the court in the way the DPP did in the case of nurse would have been an appropriate course to take, because it could mean the debate, even at this level, could be properly informed by what position was being adopted.
I don't understand. What evidence are you talking about?
Well, even what their practices would have been helpful. In what happened in nurse is they actually discussed in detail the prosecutor code and how their decision-making in relation to that. That appears in the printed case. And we have no discussion of that, how the prosecutor's code was applied on the facts of this case.
That wasn't the complaint being made. I mean, the complaint was that they're proposing to lead a known liar as a witness, and no reasonable DPP would proceed on that.
No, with respect, I think the position was a little bit more sophisticated than that. There was a complaint made about the code.
Is that right?
I'll get my learned junior to find it, but the position is not as crude as that. A lot of the points being made to my lady-in-laws were made from the outset, and they weren't squarely addressed, and that's the defendant chose not to address it. That's their choice. But it would have been easier for everyone had they done so.
So when did abusive process first feature? It's obviously front and centre of the Court of Appeal decision.
Yeah, well, it's front and central when Mr. Benjamin mentions it in the Court of Appeal.
Thank you.
And can I also draw attention to another point, just in case there's any misunderstanding about it? As the Judicial Review Act of Trinidad isn't before my lords, but as my lords will know, my lady, Section 11 sets out grounds, and the grounds include abuse of power. Abuse of power in the Judicial Review Act is a public law complaint. That is not the same as a Bennett complaint. And that's, if I may say so, one of the difficulties about dealing with the sort of spontaneous character of the submissions as they develop before my lords and ladies. So it's no good to say, well, they knew, for example, the claimant that some criticism was being made about Bennett. They didn't until it was raised by...
Some submission was being made
about Bennett until the Court of Appeal. What I think I will do over the short adjournment is try and go through the submissions and claim form more carefully in the light of the way the submissions developed, to see what points were taken and how they were addressed by the claimant at the outset. And I also, in this context, want to refer to another issue about the approach that's appropriate to take, was the role of the DPP as a Minister of Justice. Now, one of the difficulties that we have is we don't know what the position was being taken by the DPP, for example, about the Galbraith submission of no case to answer, a point made that the Galbraith point was made both before the trial judge by the prosecution and before the Court of Appeal. Now, with respect, it's obvious that this isn't Galbraith Limb 1, that there's no evidence. It's Galbraith Limb 2. Is the evidence tenuous? All we have in the written submissions is that there's a potential Limb 2 submission. We have no idea about what position the DPP would adopt towards it.
Well, wouldn't that depend on the evidence that had been led?
Well, even the difficulty is that we have absolutely nothing to work with. So we're told that there's a potential case of being tenuous. It would be just helpful to have some idea of the factual basis for some of the points being made.
This might all point in the direction of all these issues being resolved in the criminal proceedings.
Well, let me just go on with the chronology, because the chronology is quite important. What happens next is that judgment is given on the 3rd of June by the High Court. An application is made for a stay pending appeal. The Court of Appeal gives their judgment, they give their judgment ages anyway, but when the case gets to the Court of Appeal, there's no application for urgency, and there's no application for a stay. And in those circumstances, the Court of Appeal give judgment on the 6th of June of 2022, some 3 years later. So what the case comes down to in terms of...
Just tell me, were the defendants out of prison by then?
They were released on the 6th of 3rd of June.
So there wasn't effectively a stay of the effect on them of the judicial review judgment.
But it would have been open for the prosecution to say, well, hold on a moment. We want to take this criminal trial. We want to proceed with the criminal trial. The first High Court judge got it all wrong. But they didn't do that.
But what would the stay be in this case? Stay of what? Once they were released?
It could have been, well, perhaps I'm wrong, but if they had got a stay of the remedy orders, I think there was a certiorari, I'm assuming, was granted. Then Charles, the position about Charles would kick in. They would remain people charged with murder and be, on the Trinidad then practice, remanded back into custody.
Well, as I understand, it's not just a practice. The law is that somebody charged with a murder is remanded in custody.
Well, it changed with Charles No. 2, which my Lord Hodge decided. But that was the position until July 2022.
Yeah.
So they could, but what's happened here, which is with respect slightly odd, is no steps are taken to pursue the criminal case. No steps are taken to get a new prosecution team, and yet the board is told, well, all of this should have been resolved in the criminal case. Well, how? And that, with respect, reinforces the concern which my lords expressed earlier about, I think my Lord Reid, about the difficulties of expressing a view about a criminal case when there's actually no factual material to go on. There are hypotheticals which the board has been asked to deal with, but no more than hypotheticals. And in that sense, this case is not a very satisfactory vehicle through which the board can express views about judicial review. Points were made, but they're only points. That's the trouble. And with respect, we would, in our submission, it's surprising if this was to be treated as a criminal case with the whole trial, that no steps were taken by the DPP to expedite the appeal, but they didn't. I mean, it could have happened. Say, for some reason, the defendants, so the criminal defendants, my clients, remained on bail. That didn't preclude the possibility of there being a criminal trial and the Court of Appeal giving judgment a lot faster than in June 2022. So this is an entirely academic exercise. That's what it comes down to.
Well, the jury had presumably been discharged.
I think by
then.
then.
The verdict.
Yeah.
But the defendants hadn't been discharged. They still faced the charges, didn't they?
The indictment was quashed.
But the indictments had been quashed.
Well, the indictment was quashed. Yes.
Yes, which is why I think some form of stay should have been sought. In the process, I mean, this is just a hypothetical case. It's become that because of the way in which the case was allowed to develop. I don't say that with any enthusiasm, but it is a very odd feature of the way the case has been litigated that there has been, since the 23rd of June, when the prosecution team left, no possibility of a criminal trial. And that reality has been not addressed by the DPP at the Court of Appeal level either.
Why do you say there was no possibility of the criminal trial as from the 23rd of...
Well, because there's no point to prosecute it.
Well,
yes,
I think Lord Reid has already made the point that...
We've been round this tree a few times.
Okay. Well, the point I'm making is simply this: is that there were steps that could have been taken and weren't taken to deal with the prospect of a criminal trial addressing these issues. They just simply weren't, and that, with respect, in our submission, results in this: is that all that the board can do is speculate on what the potential arguments might have been had there ever been a criminal trial.
Well, that's a situation which the judge was inevitably in, and the Court of Appeal, and we're reviewing their decisions.
No, I understand that, but all I'm saying is no steps were taken to preserve options. That's all the criminal option. That's really what it comes down to. No steps were taken to preserve the criminal option. So in that sense, this is a truly academic case. I'm not saying that academic case C. Salim, for example, are of no importance. I'm not saying that, but it does mean that it takes the wind out of quite a lot of the points that could be made. And I also want to draw attention to a number of other points, which are some of which are made by the Chief Justice, Chief Justice Archie, and that the court, the role of the court in the DPP is to protect the criminal process, and that's part of the reason why I expressed the points I made earlier. That's at 264.7. Another oddity which the Chief Justice refers to is effectively the DPP might be inviting the jury to find that the witness, Mr. Benjamin, was more credible than his own counsel, because there's going to be, if there's a dispute between counsel who were the witness statements to the interview on the 23rd of April, or how that's supposed to be resolved. And he refers to the fact, the Chief Justice, to the breach of the prosecutor's code. As I said, it would have been so easy for us to be met with the nurse answer, look, we've looked at this carefully and there is no breach of the code. It says it's just left hanging in the air. So, because of the way the case is now being put, which is the hypothetical, had this case gone to a criminal case, it would have been better for it to be dealt with there. That kind of makes it quite difficult for me to respond to a number of the different submissions. But what I think it might be convenient is if I reflect over the shorter term what is the most sensible approach to take, because it's very unsatisfactory, frankly, to be put in a position like this where a different approach could have been taken, which might have made it rather easier to know what the arguments are, which were live issues and how they were being put, and they simply weren't.
Are you inviting us to effectively to adjourn slightly early to give you some time to consider your position?
Well, I'm not going to say, just to consider how to address, because I obviously,
that's what I meant.
Take note of the points my lords have made to me and my ladies, so I need to reflect on what the best course is.
Very well. Well, in that case, we'll adjourn and resume at 2 o'clock.
Thank you.